Okay, welcome back to our third video on contract law. Where we left off last time was we briefly discussed what the elements are that are required to form a contract. Remember, offer, acceptance, and consideration. And then we explored a little bit about what an offer is, what goes into it, and what's required to make an effective contractual offer. So from here, we're going to move on to talk about the other two elements, acceptance and consideration, and then explore next a situation where you may not have a contract because those elements are not there, but we may still have a remedy under another theory, another legal theory called promissory estoppel. But first, let's open back up our. Let me first minimize myself here. And then open back up to where we left off before. Again, to make an offer, your offer needs to convey a clear intent to become contractually bound, and not just some sort of hope, in some hope that maybe something will occur in the future. It has to be clear that you have something to trade, and what it is that you want in exchange for it. And number two, there you see basic terms and conditions. Those need to be clear in the offer as well. Now, this is one of those rules that will change, will be altered slightly. This is one of the first examples of that in the next chapter, where we talk about goods contracts and the rules under the Uniform Commercial Code, or the UCC. You'll see there can be some terms and conditions that are missing from the offer and still have a valid contract. But for now, we need to make sure for contracts that we're talking about in this chapter, namely service contracts, you have to make sure all the basic terms and conditions are there in the offer. And then, of course, number three, it has to be properly communicated to the party that you're intending to enter into an agreement with. And of course, you can make an offer, and there are situations where that offer could be terminated. Generally, if you have made an offer anytime before the person that you're making the offer to, who we call the offeree, you can terminate the offer by simply communicating that you're revoking it before the offeree has accepted it. In some cases, you may actually stipulate that there's a time frame for which they have to accept an offer. And if you say that you have 10 days, for instance, to accept the offer, then without any further communication, that offer will terminate once those 10 days have elapsed, or 5 o'clock by next Tuesday, or whatever the requirement may be. Another way that the offer can terminate is when the offeree, the person that you're sending the offer to, comes back and says, "I'll accept what you are offering," but the offeree adds a new condition to it. The general rule here is that that's considered a termination of the offer, and what would have been an acceptance now becomes a counteroffer. So, and as you'll see in the next slide on acceptance, it's important to be a valid acceptance that you accept exactly what the offerer has offered. So if I say that if I ask you to paint my house for $2,000, and you come back and you say, "I will do it for $2,000, but I also want you to throw in an additional service for me. I want you to wash my car in addition to the $2,000." Now, that has terminated the original offer, and now the offerer, the person who would have accepted it, has now become the offerer because they've made what is considered a counteroffer. So that is another way that the original offer can be terminated, and the roles can be switched there, where the original person who made the offer is now the person who has to accept what is a counteroffer or a new offer. Also, the offer could be terminated by law if what you're contracting for becomes illegal, or maybe the subject matter of the contract has been destroyed through no fault of your own and in an unforeseeable way, then it may be terminated in those ways as well. So the acceptance, again, just like the offer, has to be clearly communicated to the person making the offer, and it must be unequivocal and can't add any new conditions to it. So you can't, again, because if you do, we may still be able to form a contract, but the offerer, the person who would have accepted it, who adds a new condition, now is not the person to accept. They are now the person making the offer. So valid acceptance of whatever I'm offering has to be unconditional. It has to be exactly, it has to accept precisely what I'm offering and nothing more. It has to be unequivocal in the sense that it has, just like the offer, it has to evince a clear intent to be bound by your expression. So just like an offerer may say, gee, I'd like to sell my car if I could find the right buyer, that is not a clear expression to be bound to you in particular for a certain price or for some certain trade for the car. And in the same way, the person who's supposed to accept needs to be unequivocal in their acceptance. And if they were to say something like, well, gee, I'd love to buy your car, if I could get the money together and if the price is right, that is not a clear expression to be bound to a certain exchange at that point in time. So again, the elements here: offer, acceptance, and consideration. We talked briefly about offer and acceptance. Very important concept when trying to decide if we have an actual remedy for a breach of contract. Is the third element, which is consideration. I've at least alluded to this in some of what I've said and in some of the examples that have been showed. Consideration is the glue that really binds the two people together who have exchanged these ideas. Consideration is what each party is doing or not doing in exchange for whatever the other person's doing or not doing. These are things that both of you were not legally obligated to do ahead of time, and it's what sort of entices the other party to exchange whatever they're promising to exchange. So in the example I gave, and in some of the other examples, but I gave a pretty simple one about mowing the lawn. If your friend says, I'll mow your lawn when you're on vacation, and you don't really, he doesn't really say anything to entice you to exchange anything for that, then we probably don't have a contract because we don't have consideration. You could simply say, yeah, I mean, I accept. I don't mind if you do that, but I didn't say that I was going to do anything for you in exchange. And that's why that would fail as even an oral contract, because I'm simply doing you a favor. And so if I come home and you haven't done it, I can't really, in general, under a breach of contract theory, I can't be held liable because you never really promised to give up anything in exchange for it. And that's why it's not fair to let you, as a person who didn't get their lawn mowed, to then make a court do something that was not, for which there was no consideration in enticing the man to complete the task. And of course, something could have just come up that prevented him from doing it, and we're not going to hold him liable on a breach of contract theory again because that you gave no consideration for his in exchange for his willingness to mow your lawn. Now, on the other hand, if he says, "I'll do it in exchange for you giving me something," like even if it's in the previous example I gave, he said, I usually do it for $40, but because you're my good friend and I want to give you a nice lawn to come back to when you come home from vacation, I'll do it for you for $20. Well, now, once I say yes to that, I've now put something up of mine that I'm expecting to be able to hold you liable to your on your representation that you would do that. So that's something that I'm telling you I will exchange that I wasn't otherwise legally obligated to exchange. I didn't have to give you any money, $20 or $40. And so when I get home, we may have there a sufficient contract because there was, assuming that the offer and acceptance were valid under the terms that we discussed earlier, there now is consideration because the one party has offered to do something he's not obligated to do, which is to mow your lawn, and you've offered to do something by paying him that you weren't otherwise legally obligated to do, and you may also be promising to do some other things in there. You may be implicitly promising to, give your normal landscaper the day off so that he can come and do that, or to give him access to the to the property or other tools he may need.